morning, Your Honors. Counsel, I'm Roy Wasson, counsel for the appellant, Dorothy Towne. She calls herself Towne, attorney at law. I'd like to reserve 5 minutes for a rebuttal. There's the issue, the overall issue is whether default final judgment should be reversed here, and it should be reversed because it's void for 3 reasons. But before I get to the merit of the argument, I'd like to just put in the context in which this argument is raised, and that is Florida public policy that favors trial on the merits, and that this court has held in the cases, including the Hunt exterminating case cited in our briefs, that if there's any reasonable doubt about the propriety of a default, then trial on the merits should be allowed. And so here the default was void for 3 reasons. First, there was no service of process or waiver of service of process of the complaint for damages in the case. Second...
Can I stop you there? I've been a lawyer for 39 years, and I've never heard of accepting service on part of a complaint and rejecting service on the other part. Can you help me understand that?
I haven't heard of it either, Judge, but that's what was done here.
Well, and that's your argument here, though, and the trial court basically said if you accept service, you accept service, and that's what the trial court found. So if there is a way to accept part of the service of a complaint, I need to understand that, because I can't.
Well,
I'm not smart enough to figure that one out by myself, so you got to help me.
And you know, I don't think there was a service of any part of the complaint. I think she expressed a willingness to accept service by mail, but Rule of Civil Procedure 1.070 subsection I sets forth specific procedure for when service by mail is to be permitted. And First, there needs to be a request, a formal request by certified mail that has the copy of the complaint on it to request, will you accept service by mail? And then that has to be accepted formally. I think that Ms. Towne's letter that says she will accept service of the declaratory action, I think that was not even really acceptance of service of that part of it. I think that was an expression of a willingness to accept service on that part of it, but then the plaintiff never complied with the procedure under 1.070, and so basically she sat there waiting.
But her initial filings in this case did not challenge jurisdiction for failure of service. Her initial filings, I mean, you've done this a long time, you know how that works. If somebody is going to challenge a jurisdiction of court, they make a limited appearance solely for the purpose of challenging it. She didn't do that here. And the law is pretty clear. You don't do that, you waive it.
Well, if there is no service, if there is no service, and there was no service in our opinion of the damages action, if there is no service, there's nothing to contest, nothing to challenge.
Well, she eventually filed things. So she obviously submitted to the jurisdiction of the court.
Well, after the clerk's default was over, that was too late. It was too late to waive it by then, Judge. Any waiver to jurisdiction, I think, would have had to have been prior to that. Counsel argues that all the stuff that's a waiver, that was long after the fact. Trying to get the genie back in the bottle, I guess, some way, but Judge, by the time of the defective service, there was no waiver. If I could continue here, I was going to get back into the specifics of that more after I went through the outline, the overview. The second reason that the clerk's default was invalid, was void, was because Towne had served a paper under Rule 1.500, only permits defaults where the defendant has failed not just to file a paper, but to file or serve a paper. And third, Vaka was on notice that the defendant was an attorney who intended to defend the case, and as many cases we've cited in our brief, and I'll get into the argument of them, indicate that where a party knows that the defendant intends to defend the case through counsel, it's error to enter a default without notice. Now, I want to make it clear that my second and third arguments here about the service of a paper and the notice that the defendant intended to defend, both of these grounds invalidate the default even if there was service, even if there was service of process, right? Even if there was service. So we don't have to win on all three of these arguments. Each one of them stands on its own. So I'll now go back to that first argument, that there was no waiver of service of the damages action, at least, and I think no proper waiver of service on all of it. The Fourth District case of Alvarado versus Cisneros cited in our briefs that a judgment entered without service is void, and that cites this court's decision in Great American Insurance Company versus Beavis from 1995. If there's no service, a default is void and the judgment is void. Here, Towne's only agreement to waive service was quote, for the declaratory judgment action. That limited waiver appears many places in the record. I've written down page 83. And Judge, I'd like to make it clear that both sides recognized that this waiver was only going to be for the declaratory judgment action. Mr. Vaka's paralegal mailed a copy of this complaint with a letter, and I've got a couple of cites to pages 68 and 74 of the record where the paralegal says, I'm now sending you, I've now sent the declaratory action.
Why aren't we bound by the law of the case here? Because in our previous action, we basically have determined that the default, or her ability to challenge the default was unpreserved and otherwise found it to be without merit. Here we are again arguing the same issue again. Why aren't we bound by our previous decision?
That challenge was not based upon that challenge was not based upon the invalidity of the acceptance of service. That challenge was based upon Ms. Towne's motion to quash the substituted service of process, and I think I have the record site here.
Well,
on April the 9th, 2015, Ms. Towne filed motion to quash substitute service of process and vacate the default. When that was denied, that was based upon to asking to vacate the default based upon the substituted service, not asking to vacate the default based upon invalid acceptance of service. And so when that went up on appeal before the court, I didn't handle that appeal, but my understanding of it is that any challenge to service through waiver, service through acceptance of service, was not preserved for that appellate review because that was not what was the motion, the motion challenging the service in that case. So if the appellate decision there said it was not preserved, well, good. It was not preserved, and good. It had not. That argument had not been made, so we're making it here on appeal for the first time, so the law of the case doesn't apply. Going back to the second argument about the scope of the waiver, if there was any waiver, and I don't, as I said before, I don't think there was any waiver because while there was an expression of a willingness to waive for a part of the case for the declaratory action, the plaintiff did not then go forward with the required procedure under Rule 1.070I and do it. So Ms. Towne sat there waiting and waiting and waiting, and nothing happened. That's why nothing was filed. But just to make it clear that the parties knew that what she was waiving was not waiving service of a complaint for damages, as I said, Vaka's paralegal sent a letter saying, I'm enclosing, quote, the declaratory judgment action. And you got to put this in context. The record reflects this. During the course of these discussions about the declaratory action and waiving service of process, the parties were in heated discussions and negotiations concerning the shape of the table, as they said in the Vietnam peace talks, about is this going to be AAA arbitration? Is it going to be single-person arbitration? They had various proceedings on what sort of arbitration was there going to be if there was going to be arbitration. And so that was the first hurdle to get over about whether or not there was going to be arbitration. So certainly, in fact, the complaint reflects that the damages count was only in the alternative should it be determined that there was not going to be arbitration. So merely by accepting service of the declaratory judgment action, that's not a concession that this case has been properly served on the damages count. It was not. The judgment is, the default was void, and therefore the judgment is void for that purpose. Just going to that argument about Rule 1.500. I like the language from the Palacine case from the 4th District in 2013, describing what is meant by service of a paper under Rule 1.500 that prevents a clerk's default without notice. And the quote is, quote, any written communication that informs the plaintiff of the defendant's intent to contest the claim, end of quote. And here, you don't write and say, I'm willing to accept service of a declaratory judgment action without that being a written communication that informs the plaintiff that there's going to be a contest. If you're not saying, if you're not going to contest it, you don't say, I'm going to accept service on the deck action. You say, all right, let's go to arbitration. Let's have an arbitration. By saying I'm going to accept service is saying I contest it. The rule is clear. The paper doesn't have to be filed. It only has to be filed or served in the action. Once this paper was served, there cannot be a default by the clerk without notice. The default is void. And the third reason for voidness is this court's great decision in Makes and Models magazine. That and again, this argument assumes that there has been valid service. Assume that there has been valid service. And the defendant doesn't do anything about it, but doesn't do anything about it because they're talking to the attorney representing the defendant is talking to the plaintiff's attorney, and here they were about the shape of the table, about the declaratory judgment, about whether there's going to be arbitration. The defendant knows that counsel intends to defend the case. And all these cases have to assume there's been valid service and there's been no paper served or filed. There's been nothing filed of record. But I think it's a good law that where the where the plaintiff knows that the defense has a lawyer and they're not just folding and contesting it, you can't just go to the clerk and get a default ex parte. You can't do it. It renders it void. Here, the parties were involved in multiple discussions about arbitration. The plaintiff knew the defendant was defending. There was no reason not to give notice of the default at that time. I think I addressed the question about law of the case as best I could. The issue was not addressed in the last appeal. It was not preserved, so it's been preserved now. Unless there are any questions from the bench, I'd ask that the court reverse and let's go back and try the case on the merits.
Morning, Your Honors. My name is John Trujillo. I'm here on behalf of the Appellate Vaka Law Group. May it please the Court, Mr. Wasson. The first thing that I want to point out with regard to Mr. Wasson's presentation is that Rule 1.070 was not raised in either the initial brief or in the reply brief, at least as far as I can tell. I'd like to start with addressing the entry of the clerk's default first and focus on the law of the case, because that's where I believe that the focus needs to be, at least initially. This Court, in the prior appellate opinion that was authored by Judge Valenti, has already ruled that Ms. Towne failed to preserve a challenge to the entry of default. And although Mr. Wasson has stated that that was not raised in the first appellate opinion, the last paragraph literally states of that opinion, finally, to the extent that Ms. Towne seeks review of the issuance of the clerk's default, we affirm because the propriety of that default has not been preserved for review. Now, the appellant claims that even though it was not preserved during or prior to the first appellate opinion, that after the opinion was rendered, that she could have gone back and somehow, by some legal construct, gone back and preserved the issue of the impropriety of the clerk's default. And that cannot be the law of this state. The purpose of the law of the case doctrine is to, quote, lend stability to judicial decisions and the jurisprudence of this state, to avoid piecemeal appeals and to bring litigation to an end as expeditiously as possible. That's a statement by the Florida Supreme Court out of a 2012 case titled Delta Property Management, which is cited at page 25 of our answer brief. To hold now that she did not preserve, that she did preserve the issuance of the clerk's default for review would run counter to this concept. And what the appellant is missing out on is that, and ignores, that in order to successfully challenge, much less preserve, an argument that is based on insufficiency of service of process or lack of personal jurisdiction, it's got to be done on a timely basis, And if this Court were to hold otherwise, that she did go back and successfully preserve the issue on the issuance of...
Interestingly enough, a challenge under 1540 with regard to the lack of jurisdiction, I think that's B4. Although the rule says timely, the decisional law has said there really is no time limit to challenge a void judgment. So I'm having a difficult time taking your argument says because she failed to preserve it, this rule no longer applies on a post-final judgment challenge under 1.540B. I mean, it may be logical to argue she's already tried to have one set aside for lack of due process, and this is the same thing. But when it says failed to preserve, then I don't know what the issue would have been because nothing was brought before the trial court to rule. So how does that render 1.540 negatory? And that's...
How does it render it what? I'm sorry.
Well, you said that because Judge Valenti's opinion, and you're absolutely right, you quoted exactly correct, was not preserved, that's the law and we can't look at it. But that would in effect say that Rule 1.540 cannot be utilized to challenge a post-final judgment lacking jurisdiction, which would render it void. And I'm not sure that how that works, because then you're saying the direct appeal nullified the prospective application of a post-final judgment rule.
First of all, under 1.540, the trial judge may decide to not vacate a judgment that is void under that rule. So the trial judge, and that is part of what's on appeal today, is the decision to not vacate the final judgment.
Has the appellate's decision on a void judgment used the word may, or do the appellate decisions instruct us that you shall set it aside whenever you find it?
I believe it's may. I don't know the answer to that question, Judge Castanueva.
All right, I'll check because my recollection is to the contrary, but that doesn't mean I'm right. It just means that's what my recollection is.
Yes, sir.
So I'll check.
And certainly, and I appreciate your concern on that, but you know, Rule 1.540 also says that the motion has to be filed within a reasonable time. A reasonable time. And under the facts of this case, we're dealing with a lawyer that accepted service of a complaint and later turned around and agreed to, and says that she only agreed to accept half of it. I think that any one of us in this room, had we been personally served, would have known that she needed to do something immediately, not 2 years later, after the initial clerk's default was entered, after the first final default judgment was entered by Judge Wolf, and certainly not after the final judgment was entered by Judge Cook on December 14th of 2017. But if the court holds that the law of the case does not apply to this action, then the rule of civil procedure requiring you, which is Rule 1.140, requiring a litigant to raise the defenses of insufficiency of service of process and lack of personal jurisdiction, is suddenly eviscerated and cast aside. And even if the law of the case doctrine does not apply to this case, Your Honors, Ms. Towne unequivocally waived her right to challenge the entry of the default at the very outset of this case. Now, we know that Ms. Towne eventually challenged insufficiency of service of process and eventually challenged a lack of personal jurisdiction. But like I just said,
Under any of the rules that the appellant proceeded, is the appellant required to say, I have a defense and here's my proposed answer attached to my motion with my defenses and affirmative defenses attached to it? Was any of that ever complied with, and is it appropriate in this instance?
I think that any document that is served and filed with the court that even mentions remotely lack of personal jurisdiction or insufficiency of service of process is appropriate. I don't think that it matters that it needs to be attached to a complaint.
Generally, sometimes when you set aside a motion to set aside a default, you have to comply with a number of conditions precedent, if I can use that term, indicate you have a due to excusable neglect or whatever, that you have a viable defense. And many times counsel will attach a copy of their proposed answer so that the court knows that they are able to contest that. In any efforts to set aside default, was any of that done?
No, sir, it was not. In fact,
And your default only admitted liability, right?
absolutely.
And
That's all I asked
you had to file
Judge.
on the merits. And so at that point, for damages, the appellant could have appeared.
Absolutely. Absolutely. Rule 1.140 says that if those specific defenses are not asserted in the initial pleading, that being the defenses of lack of personal jurisdiction and insufficiency of service of process, that those defenses must be deemed to be waived. Must, not may, not can, must be deemed to be waived. So did she do that in her first pleading? And that notice of unavailability, which was the very first pleading that she entered into the court's docket? She absolutely didn't. Instead of seeking protection from jurisdiction, it appears that she was simply seeking protection of her vacation time. And if you don't consider a notice of unavailability to be a quote-unquote pleading, then let's look at the next pleading that she filed. That was entitled A Motion for Entry of Judgment and Imposition of Sanctions against Vaka Law Group, which was filed on January 20th of 2015, which was 2 months after she received notice of the entry of the clerk's default. That's at record number 59. Within that second pleading that Ms. Towne filed, she merely attacked the contract that was made the basis of the suit. She had an issue with the legality of the arbitration provision, several other issues about the fee that my client was charging her for work that was performed on her own behalf. That pleading mentions nowhere within an issue or an objection or a problem with insufficiency of service of process or lack of jurisdiction. And in fact, the first time that lack of proper service was ever raised was on March 25th of 2015. That was like 5 months after the clerk's default was entered. That was insufficient to remediate her prior waiver of this challenge. So in sum, on this issue, Your Honors, Ms. Towne has and always will have waived her right to contest lack of personal jurisdiction or insufficiency of service of process. And one other thing that I want to note with regard to her failure to preserve any challenge to lack of personal jurisdiction was the fact that she actively participated in the case. And she essentially entered a general appearance by virtue of the filings of all the pleadings that we just discussed, in addition to an answer to the complaint. And by the way, when she did file an answer to the complaint, number one, it admitted that she executed the contract, and number two, it admitted that she owed a reasonable amount for the fees. Guess what was missing from the complaint? any affirmative defenses. There were absolutely none, and to this day I haven't seen an affirmative defense pled by Ms. Towne to the contract. Now, with
Ms. Towne's answer was directed to count 2 of the complaint at record page 63.
That is correct, Your Honor.
Submitted all facts except number 10 and 11,
That's correct?
and those were denied. And then 21 and the rest were denied. Okay. So she is, I'm listening to make sure I'm looking at the same document you were referring to.
You're referring to the correct document, I believe that was filed on March 25th of 2015, Your Honor?
7:15 a.m. according to the Hillsborough County Clerk.
Thank you, sir. Regarding Ms. Towne's contention that Judge Wolf didn't have the authority to enter the default judgment that he did on April 20th of 2015, what the appellant is failing to recognize here is that the entry of the clerk's default against Ms. Towne absolutely terminated her right to defend the matter, except the ability to file a motion to set aside or vacate the default judgment. We've cited the Dage case, which this court issued in 2012 and is cited at pages 15, 23, 32, and 33 of our answer brief. The Smith case, which is a 5th DCA opinion from 1993 at pages 15 and 32 of our answer brief. And the Hines case, which is a 3rd DCA case and which is cited at page 15 of our answer brief, all in support of that principle of law. And because Ms. Towne had already waived her right to contest the sufficiency of process or lack of personal jurisdiction, because she failed to file any pleading prior to the entry of the clerk's default, failed to file a motion to set aside the default, Judge Wolf had the clear legal authority to enter the final default judgment against her on liability only on April 20th of 2015.
At the time that Judge Wolf undertook that order, the record of the clerk that provided would have shown that the defendant had filed a motion for entry of judgment and imposition of sanctions, had filed an answer, and had filed a motion to dismiss?
Yes.
And so notice would normally go out from the clerk's office to anybody who filed, so Ms. Towne would receive notice that these were about to be done?
If you're referring to the notice from the clerk to her, which is
someone
required.
does the record demonstrate that Ms. Towne was noticed that the motion for default final judgment was going to be proceeded upon?
Absolutely, Your Honor. Well, after the default by the clerk was entered on November 18th of 2014, 2 days later I forwarded her the motion for final default judgment that I filed before Judge Wolf, which attached to it, amongst other things, the clerk's default that had been entered against her. She was ultimately advised by the clerk, as well as required under Rule 1.500, that a default had been entered upon her second or third attempt to file documents within the document.
You probably said this, but how much time had passed between the motion for default by the court and her motion to set aside that default?
I believe that the first one that she filed was on March 30th of 2016 to set aside the default. Now, having said that, there was also a motion to quash substitute service of process on the defendant and to vacate the default entered by the clerk, which was filed on April 9th of 2015. So that would have been, 5 months after the clerk's default was entered. Yes, sir. Now, that motion, by the way, really only addresses the substitute service of process issue, which Ms. Towne never grasped was not the basis for entry of the final default judgment by Judge Wolf. It was her personal service of process, which is replete with references throughout the hearing transcripts in this matter. Now, with regard to whether or not Ms. Towne was entitled to notice because of my alleged actual notice of her being represented and her actual intent to defend the case, what we have to do is look at the cases that the appellant cited, which all do stand for the proposition that if you've got actual knowledge of intent and of representation and intent to defend, sure, you have to give somebody notice to do that. However, in all of those 3 cases that came out of this court, Makes and Models, Jacaranda, Lloyd, the facts in those cases were so completely different from what we have here that it's no wonder that this court held that the parties that were defaulted were entitled to notice. For instance, in Makes and Models, the party that had moved for default was already involved in litigation with the same parties over the same set of facts in a different court. Despite that fact, The party that moved for default never gave notice to his opposing counsel of the application for the clerk's default. And again, it's not surprising that this court found that they were entitled to notice of the application and that the default should have been set aside.
It's the most interesting day today. Everywhere we go, there's a Judge Volante opinion. In the earlier case,
That
this
never
one.
happened.
You're very popular.
Countervailing opinions that clarify my opinions by Judge Casanova, so I think he's fixed everything I might have messed up.
Well, I don't think you messed up the first appellate opinion that you issued in this case, Judge. And that goes back to the fact that she never preserved the clerk's default issue for review in this case. I want to continue with regard to the other cases they've cited regarding actual knowledge of intent to defend and representation, and point out that in the Lloyd case, the facts establishing knowledge of intent to defend and counsel's representation were even more broad than in makes and models, to the point where this court noted that the facts were quote-unquote overwhelming. And there was like 5 or 6 different facts that this court used to look at and say, wait a minute, there's no way you couldn't see here that they intended to defend this case. And again, that involved the same property involved in other litigation involving the same parties as well. In addition to those 2 cases, the appellant has also cited to Jack Aranda, and that case again found knowledge of intent to defend based on the fact that the parties had been involved in litigation over the same piece of property in another forum at the time that the party that moved for default did so and failed to give notice. In this case, there are simply no facts of record that fit within the confines of makes and models, Lloyd, Jack Aranda, that would support the contention that the default should have been vacated in this case. And let's not forget that she also had to raise the issue before the trial court as well on a timely basis before further pleading, which she did not do. The only thing that was apparent to me, based on my dealings with Ms. Towne and her husband prior to the filing of this complaint, not all of which are in the record, but the only thing that was apparent to me, that there was no intent to defend, there was an intent to delay, and that's all there was. And if I can make an analogy of their subsequent performance being an indicator of their former intent, I will, because the way that they defended, quote unquote, this case shows that they didn't really defend anything. They filed the same motions over and over again, attacking the same issues. It was exasperating to everybody involved, including, I think, the trial judges. At the outset of the case, they objected to arbitration and said it was illegal. Then 6 months down the road, turned around and tried to enforce the arbitration provision, which was incidentally part of the first appeal that came before this court involving these parties. And most importantly, at the final evidentiary hearing on this matter, Your Honors, on December 14th of 2017, at the beginning of the hearing, Ms. Towne got up and walked out of the room. The bailiff had to go and grab her from the hallway and bring her back and sit her down and force her to participate in the evidentiary hearing for her to be able to contest the amount of damages, which was the only thing that was still outstanding at that point. Furthermore, she didn't present any evidence on her own behalf at the evidentiary hearing. She was cross-examined by myself, to some extent by the court, but otherwise no evidence that I recall that she was submitted, which is all indicative of the point that she didn't have any defenses to this case. There were none. In closing, Your Honors, to this day, Ms. Towne has failed to demonstrate excusable neglect, the existence of a meritorious defense, and she clearly didn't demonstrate due diligence during the progression of this lawsuit. Instead, she claims that she agreed to accept only half of a complaint, although there's absolutely no case law that says that you can do that, as pointed out by you. And she failed to respond to a complaint. She failed to follow the most basic rules of procedure by failing to initially challenge insufficiency of process or sufficiency of process and lack of personal jurisdiction. And she essentially did nothing throughout this lawsuit except to try to disrupt the orderly progression of this case, at which she was very, very successful. As a result of her actions throughout this, she should be held to account for what she did in the trial court. The clerk's default was properly entered. The motion to vacate was properly denied. The final judgment was properly entered. For these reasons, I ask that you affirm in all respects. Are there any further questions? Thank you, Your Honors.
Thank you, counsel.
Couple quick points in sort of reverse order here. Toward the end is argument that at the trial on damages, my client didn't raise any affirmative defenses to liability. Well, they weren't going to permit her to do that. There was a default by that time. She had been fighting, but it was a trial on damages. So she, don't hold it against her that she didn't raise a defense to liability at that trial.
What's difficult for me to figure out is exactly what the meritorious defenses were that she raised, because if I recall from her answer, she admitted there was a contract and all of those things. It seemed like this was just a question of how much was owed, is what I sort of divined from all of this, and that would have been where the showing would have been made at the trial on damages, which didn't appear that there was any showing.
Well,
so I'm kind of at a loss to figure out exactly what the defense strategy was.
Well, there are several references throughout the record, Your Honor. See if I have a cite to a page of it, but where it said that the defense was that it was a contract of adhesion that was not enforceable, that the contract was not enforceable as a contract of adhesion. I'll concede the court it was not done in the form of an affidavit or a verified proposed pleading to that effect, but that's the defense to liability.
It's hard to imagine a contract between two lawyers being a contract of adhesion.
Yes.
That's hard for me to get my mind around.
Well, I haven't fleshed out the merit of that defense, Your Honor. I'm just saying what the defense that I've seen.
The essence of what the trial judge had to do is determine, was the defense meritorious?
Well, if we get to that fourth ground for vacating the default of meritorious defense and due diligence, yes, but I hadn't even presented that in my initial argument. I was just going on my argument. I'm relying on the brief for that. My argument has been the voidness of the judgment, which does not require any showing of any meritorious defense. If I could continue in reverse order here, counsel made several arguments that the objection to the clerk's default was waived because the argument was not raised in the first pleading, and he cited several things, including a notice of unavailability, a motion for imposition of sanctions, and he called that the first pleading and the second pleading. I believe it's Rule 1.100 that defines pleadings and motions, and this is a common mistake. I think we all refer to motions and notices and stuff like this as pleadings, but the rules of civil procedure make it very clear. There shall be a complaint, an answer to a complaint, an answer to a counterclaim when denominated as such. A third part, those are the pleadings. Motions, notices, other things, we call them generically pleadings, but they are not pleadings, and filing of those things do not count for marking the time that...
Let me ask this. The clerk's default was entered November 18, 2014. The order on the plaintiff's motion for entered default was entered April 20th, 2015. In the interim, on January 20th of 2015, the defendant, the appellant, filed a motion for entry of judgment, filed an answer, and filed a motion to dismiss. There's no challenge. The motion to dismiss is lack of proper personal service. But the first two, does that submit you to the jurisdiction of the court and waive your challenge to jurisdiction?
The first thing, what was the first?
Filed a motion for the entry of a judgment. Filed an answer.
Judge, that backs me up to the first...
That goes back to my question to Judge.
Did
you file a limited motion to challenge jurisdiction based on service of process? It appears that was the third or fourth thing, and by then, it may be out of the bag. It may be waived.
Well, I think by then she had been beaten on the substituted, I mean, she'd only been fighting the substitute service. Here's one thing that I hadn't got out yet. It was a long time into this case before it became clear to the defendant, before it became known to the defendant, that the plaintiff was attempting to hold her in the case on this alleged waiver or acceptance of service. And here's why it was not knowable to the defendant here. After she said she's willing to accept the declaratory judgment action, not saying the damages act, after she said I'll do that, and after it didn't come in the form that the rule requires, 1.170, they got service on her daughter in a place she didn't live. They got personal substituted service by a process server on her daughter after she had sent the letter saying she would accept. Why was she to think that that mailing of the complaint to her was going to be said to be service, objection to which she would waive if she didn't raise it? When her daughter got served at the place she didn't live, I'm sure in the back of her mind, Ms. Towne thought, well, I guess they decided not to honor my acceptance of service of the DEC action after all. The whole focus became on whether that was good service, and it wasn't. So you can't fault her for not contesting the alleged acceptance.
I would advise your counsel the time has expired.
Thank you. I asked the court to reverse the judgment.
Thank you both.